Good morning, this is your Kelso Report for Monday, December 10th, and I'm your host, Clark Kelso. The United States Supreme Court was busy last Friday granting petitions for certiorari in 5 cases. 2 of the cases received national attention. First, the review of the Ninth Circuit's decision striking down Proposition 8, and the second, the review of the Federal Defense of Marriage Act, both involving gay marriage. But the court also granted review in a preemption case involving consumer protection laws as applied to car towing companies. They granted review in an arbitration case involving class arbitration, and in a case involving the intersection of antitrust law and patent law. So the court was pretty active on Friday. Let's begin with Hollingsworth versus Perry. Now, earlier this summer, the Ninth Circuit denied in-bank review of the panel decision in Perry versus Brown, striking down on equal protection grounds California's Proposition 8, which had limited marriage to between a man and a woman. The panel majority held that Proposition 8 resulted from anti-gay animus and was therefore unconstitutional under the Supreme Court's decision in Romer versus Evans. On Friday, the Supreme Court granted cert in the case, now referred to as Hollingsworth versus Perry. In addition to the merits questions, the Supreme Court directed the parties to brief whether the petitioner has standing. The court here could issue a broad ruling on the merits in the case affecting all states. It could also issue a relatively narrow ruling just affecting California, which is essentially what the Ninth Circuit panel did. Or it could hold that the petitioner, the proponent of the initiative, lacks standing under Article 3 of the Constitution. The Ninth Circuit had certified the standing question in the California Supreme Court, and that court held the proponent had standing. But of course, standing in federal court is a matter of federal constitutional law, so the decision by the California Supreme Court is certainly not dispositive. Now, in essence, the parties before the court now are plaintiffs who suffered injury by being denied the right to marry, and the proponents of the initiative, who have not really suffered any injury by the Ninth Circuit's decision, any different than any other California resident. They may have a political gripe with the Ninth Circuit's decision, but political gripes do not make for Article 3 standing. And the Supreme Court could easily dismiss the case and vacate the Ninth Circuit's decision on standing grounds. Now, while some might see this as a purely technical procedural holding, I don't think that's how the Supreme Court justices view the standing requirement. Standing helps keep the court from getting drawn into political and ideological battles, where the litigants may not have any real injuries at stake. Viewed this way, dismissing on standing grounds would be very much in line with what Chief Justice Roberts may have been doing in the health care decision last term. Essentially, keeping the Supreme Court from being the center of attention on a major policy and political issue. Now, the Supreme Court also granted review in United States versus Windsor, which involves the constitutionality of the Defense of Marriage Act. As with Hollingsworth, the case involves the issue of whether the Constitution requires recognition of same-gender marriages. The Defense of Marriage Act was, of course, enacted during the Clinton presidency, and, among other things, permits states to refuse to give full faith and credit to same-gender marriages that are legitimate in other states. As with Hollingsworth, there is also a standing question that the court has asked to be briefed. This time, because the U.S. Department of Justice has agreed with the lower court that DOMA is unconstitutional, the only petitioners are individual members of Congress who have banded together as a small group, known as the Bipartisan Legal Advisory Group of the United States House of Representatives. Once again, my guess is that the court will hold it lacks jurisdiction to decide the case, and that this small group of Congress people, who are at best by their own name only advisory, they lack standing. Both of those holdings would keep the Supreme Court out of the middle of this issue for at least the next couple of years. Now, we have three other cases where the court granted cert. The trucking and transportation industries went through a wave of deregulation in the 1990s. A major feature of the deregulation was to preempt state laws that were viewed by Congress as burdening the market. In particular, the Interstate Commerce Act, as amended by the Federal Aviation Administrative Authorization Act in 1994, and the ICC Termination Act of 1995, preempt states and their subdivisions from enacting or enforcing any law related to a price, route, or service of any motor carrier with respect to the transportation of property. There is an exception to the general preemption clause, providing that preemption does not apply to the authority of a state to enact or enforce laws relating to the price of towing services, if such services are performed without the prior consent of the vehicle's owner. In Dan's City Used Cars v. Pelkey, the relevant state consumer protection laws regulated a towing company's right to place a lien on a towed vehicle to secure the collection of storage and towing fees. The Supreme Court of New Hampshire held that these laws fell within the scope of the exception and were therefore not preempted. I'm guessing there are at least 4 justices who think the exception to the preemption clause is a bit narrower than construed by the New Hampshire courts, and that the general consumer protection laws dealing with liens and security interests don't deal with the price of towing services, which is all the exception covers. Next, we have a case involving arbitration. In its most recent decision involving class arbitration, the Supreme Court has recognized that class arbitration tends to be inconsistent with the basic advantages of arbitration of claims. Yet, in Oxford Health Plans v. Sutter, a New Jersey district court interpreted an arbitration clause that was silent about class arbitration to authorize the arbitration of class claims. And that decision was affirmed on appeal, and the Supreme Court has granted review, very likely to consider establishing a rule that class arbitration is authorized only when an arbitration clause expressly authorizes the consideration and resolution of class claims. Well, our last case involves antitrust and patent. Can the holder of a patent who is not likely to prevail in an infringement action essentially buy off the defendants with a reverse payment settlement that economically shares the patent holder's monopoly profits with the competitor defendant? When you strip away the fancy antitrust verbiage, that is the question presented in Federal Trade Commission v. Watson Pharmaceuticals. The FTC filed a complaint alleging that the reverse payment settlement between the holder of a drug patent and 2 generic manufacturers of the drug were unfair restraints on trade that violated federal antitrust laws, claiming that the settlements were simply tools that the 3 manufacturers used to avoid a court judgment that the patent was invalid or would not be infringed by the generics, thereby protecting monopoly profits that the companies divided up by means of payments from the patent holder to the generic manufacturers. The United States District Court had dismissed the complaint for failure to state a claim, and the Court of Appeals affirmed, holding that the settlement was immune from antitrust attack unless the patent was obtained by fraud, the patent enforcement action was a fraud or a sham, or the anti-competitive effects of the reverse settlement were much broader than the scope of the patent's exclusionary potential. This is an important case for the pharmaceutical industry and for the interaction of patent and antitrust laws. And that's it for today's Kelso Report. Have a great day in the law.